Okay, and a good afternoon, and thank you all for joining us virtually at the How to Trademark Your Business webinar, part of Global Entrepreneurship Week, an annual collection of events in over 170 countries that inspires millions to explore their potential as an entrepreneur. I am Evie Cruz, the nonprofit and small business coordinator at Philadelphia VIP, Philadelphia's hub for pro bono legal services. A bit of housekeeping up front. Please keep your microphones on the muted setting until it is time for the question and answer portion. This session is being recorded and will be shared with participants after the event. If you prefer, you may keep your camera turned off at all times, change your display name to your initials, and/or submit questions through the chat window. I will now introduce our esteemed expert for the day, Sima Singadia Kulkarni, legal counsel at DLA Piper. Sima concentrates her practice on intellectual property law, focusing on patents, trademarks, copyrights, and trade secrets. She counsels clients in all aspects of IP matters, including strategic IP portfolio development, patent prosecution, licensing, and commercialization. Her clients include biotech, healthcare, life science, and pharmaceutical companies ranging in size from emerging growth startups to multinational global corporations and academic institutions. Sima, thank you for joining us, and I know you have a lot of information to share, so I'll let you take it away.
All right. Well, thank you very much, Evie. Can you hear me okay? Is everything working?
I think so.
Okay. All right, great. Well, thank you very much for the introduction, and thank you everybody for making time to attend this presentation. I think you're going to walk away with some good practical advice that you can apply to your businesses and your entrepreneurial endeavors. I'm going to be covering quite a bit of material. This presentation will be available to you after our meeting today, but I'm not going to go through every single slide because I think then we'd just be here for the whole afternoon. But if you have any follow-up questions, my contact information is in the slide deck, and just feel free to follow up with me after the fact, and we can work through any particular details or information that you might need. I also wanted to let you know that well, actually, let me back up a little bit. As Evie said, I'm an intellectual property attorney. I do a lot of work in the patent space as well as the trademark space. And I've been doing this work for about 20 years. I am with DLA Piper, which is the largest global law firm in the world. We have offices all over North America, South America, Europe, Asia, Australia, and any country that you might be interested in doing business. That said, as you can imagine, a lot of our clients are very large, big industry players. However, DLA Piper has a very sincere commitment to working with small businesses as well as startup companies. So I'm going to point you to a website later on where you can access a wealth of resources that will be helpful for you as you establish your business, all the way from templates that you can use for articles of incorporation, employment agreements, and just a lot of stuff. And the advantage of getting it off of our website is that it's been put out by a reputable firm versus just finding something on the web, which might be fine, but at least this gives you a level of comfort of knowing that whatever materials that you're working with are a good place for you to start. You might still want to get an attorney to bless your final documents, but I just kind of wanted to point that out early on. So as Evie said, we're going to be talking about trademarks today. But as I was preparing this presentation, I thought, in order to really talk about trademarks, it's important for people to understand really where trademarks fall under the umbrella of intellectual property. So I think that's where we're going to start today. So intellectual property basically refers to
I'm sorry, Sima. Can you just share your screen? I think you have to pull up your presentation. Sorry to interrupt.
Okay, no, thank you. All right, here we go. Do you see that? Can you see it?
Yes, I can see it.
Okay, great. Okay, great. All right, so we are going to start with slide number 3. Intellectual property really refers to that aspect of your business where we are concerned with protecting the intangible assets. We all know how to protect the tangible assets, whether that be inventory, whether that be the building, whether that be the machinery. That, you use your gates, you use your locks, it's a physical component that is protected in the normal ways. Intangible assets, however, are different. And the considerations for protecting intangible assets are very much more nuanced than protecting tangible assets. Intangible assets are things such as ideas, such as brands, such as discoveries, such as customer lists. And like I said, they require a different level of consideration. When I first started working in this space, those considerations were different than what we think about these days. In the past, it used to be mostly the large companies that invested their resources in making sure that their intangible assets were protected. It was almost like a commodity. But after the massive technology revolution that we have all lived through, and especially in the last 5 years where so much of business and commerce is conducted in cyberspace, it is vitally important, not just for the big companies, but even more so, I think, sometimes for the smaller companies, to be really vigilant about protecting their intangible assets. And a lot of times, startups are concerned about going down this road and investigating what it's going to take care of these assets because it's expensive to do so. But I want to share with you a lot of resources and a lot of things that you can do upfront to kind of defray some of those costs. Intellectual property, I put up this image because I think you'll probably be very familiar with a lot of these things here. Like, there's a type of intellectual property that's referred to as a trade secret. There are trademarks, there are patents, there are copyrights, and that sort of thing. So I'm going to quickly touch on the 4 main types of intellectual property. First and foremost are patents. I work mostly with patents. I would say I spend about 60 to 70% of my time working on patent applications. And as Edie mentioned, I do a lot of work with life science companies and biotech companies. Just as a point of interest, right now I'm working on a patent application for a novel COVID test that's kind of like a pregnancy test that you can use at home. That's what patents cover. They cover new ways of doing things, new creations. They are very detailed documents that protect the intricacies of an invention. There are basically 2 types of patents. There are utility patents that protect mostly what you would think of as being methods of doing things, devices such as medical devices or tools, that sort of thing. Those are utility patents, and they last pretty much for 20 years. And then there are design patents which protect the ornamental design of a device or artifact. Trademarks.
Sima, I'm sorry to interrupt again. I think your slides are stuck or they're not advancing or something like that.
Oh, okay. Are you on? Do you see intellectual property IP 4 main?
I see tangible asset versus intangible asset.
Did you see? Okay. All right. Well, do you see now? Do you see?
No, it looks the same. I'm just seeing this one screen of tangible asset versus intangible asset. It's
Well, maybe Edie, maybe rather than me messing with it, maybe you take over if that's okay.
Sure. Let me do that right now.
Yeah, please go to slide number 5.
Okay. Sorry. Slide number. Oh. 5.
Yeah.
Okie dokie.
All right, so there are 4 main types of intellectual property. Like I said, we briefly talked about patents. Trademarks we're going to really get into to talk about, you know, the type of trademarks that we can have, which are basically names, slogans, logos, colors, that sort of thing. Copyrights typically are registrations that protect an original form of expression, whether that's a printed publication, whether that's a work of art, whether that's a work of music. Works of original authorship are protected by copyrights. And trade secrets are yet another category, which is something that it's an approach that people take when they feel like a patent is really not for them. The classic trade secret is the Coca-Cola recipe, of course, which is protected under all kinds of procedures and processes and that stuff. The reason trade secrets are picked over patents sometimes because patents are published. So whatever it is that constitutes the inventive aspect of that invention is published in a patent. In a trade secret, it's never published. So next slide. Yet another form of intellectual property nowadays is considered to be data. There are a lot of nuanced issues associated with data itself, privacy being a very important one there. But like I said, I'm not really going to get into too much granular detail about this. I just wanted to give you a general overview. So Evie, would you please go to slide 12? I'm going to quickly talk about the patent application process. This is, I'm not going to linger here too long, but I just thought you might be interested. The patent application process involves filing an application. In that application, you're going to describe in great amount of detail your invention. You want to get the application on file before there is any sort of public disclosure. And the reason for that is because if you publicly disclose it, even if you're just talking at a conference that is considered a public disclosure, then you have lost all international rights. In the United States, you have a 12-month grace period. But as far as filing internationally, you have to have absolute secrecy or novelty before you can file for valid patent protection. For most of my clients, we are filing what's called a provisional patent application at month 0. And that serves as a priority document, kind of a placeholder. Then at 12 months, we file what's called a PCT application, which is a global filing. The PCT is published at 18 months, and then at 30 months, that application enters into individual countries where you want to get protection. There's a parallel process where we can just file in the US, but for timing reasons, I'm not going to get into that. An important thing to remember here is that if you have a process that you think needs to be protected by a patent, as soon as you file an application, a patent application, you can start using the words patent pending on that invention. So you're putting the world on notice that this is my device, this is my methodology, this is my intangible asset, and I've applied for a patent on it. So I think that can be very valuable to a lot of startups because investors like to see that you've been proactive about protecting your asset. Then that's a really nice way to legitimize your business as well by slapping the words patent pending on it. You can spend all kinds of money to file a provisional application if you engage an attorney, depending on where that attorney is and the type of detail that attorney goes into in order to create that application. You can spend anywhere from $5,000 to $50,000 to get the provisional on file. Or you can file the provisional yourself, and there are ways to do that as well. I won't, like I said, focus on that too much, but I did want you to know that the patent process is a process. It's an application process where there's a lot of back and forth with an examiner. And eventually you'll get to a set of claims that defines your invention. And that process can take anywhere from 2 to 3 years, both in the US and overseas. Edie, let's go to slide 13, the next slide. So as compared to patents, copyrights are a lot more straightforward. What you're doing is you're not submitting an application, you're actually submitting basically an application for registration. You're registering your original work. And for the most part, I advise my clients to do that by yourself because it's quite inexpensive. The registration fee is, I think, $35 right now. So, you know, if you've created like a special kind of a menu, or you've created a particular type of description that goes with a device that you're selling, such as a sheet of instructions or whatever, and you want to protect the content of that piece of original authorship, I would advise you to go ahead and submit a registration for a copyright. Excuse me, I'm turning my phone. And that is very straightforward, very easy to do. And I'm going to provide you a link to the US Copyright Office later in the presentation as well. Slide 14, please, Edie, the next slide. Trade secrets are yet another form of protection for intangible assets. Trade secrets, there's no really set way to go about protecting trade secrets, but it is important that you develop an internal policy to protect your trade secrets. So if you have a particular type of a recipe for a muffin, for example, or if you have a particular procedure for manufacturing a particular device, something along those lines, and you don't want to apply for a patent application on it, you want to create a policy that you share with all your employees, and you make sure that you implement that policy, that you stay on top of it. I would suggest that you put it down in writing. I suggest that you share that policy with your employees on a regular basis, make sure that it's kept updated. And when employees leave, that you have a provision in that policy as far as how you're going to take back that top trade secret and what your employees' obligations are going to be to you as far as protecting the information that constitutes the trade secret. Now, let's get into trademarks. Next slide. I think almost everybody is familiar with what a trademark is. This slide shows some pretty common trademarks. I used some trademarks that you are probably familiar with from attending this particular conference. Of course, there's the Amazon trademark, there's the Coca-Cola trademark, which up until recently I thought was the most valuable trademark. But I did a little bit of research for this presentation, and I learned that Apple's branding has actually surpassed Coca-Cola's branding with respect to value. And in case you're interested, Coca-Cola's brand is valued at about $80 billion. That's the brand itself, not the company. The brand is valued at $80 billion. Apple is branded at about $98.3 billion. And this was from an article in 2013. So I can't even imagine what it's worth today. I also wanted to share this slide with you because if you look at the bottom there, you see the Jaguar logo and you see the Puma logo. There's a lot of similarity there. And there's a lot of litigation between these two companies as well. But as you can imagine, they have the resources to fight each other endlessly. But since they basically travel in different channels of commerce, they've been able to coexist. I just kind of wanted to point that out to you because I would not ever suggest that if you were getting into the business of cars or getting into the business of athletic wear to have a logo that mirrors any of the other logos that we're used to seeing. But when you are a larger entity and you have the resources to really develop your brand and litigate it, hire armies of lawyers and enforce your branding, then that's different. But when you are a startup, it's really important to make sure that you conduct the appropriate searches to make sure that whatever it is that you want to trademark or protect, you're doing clearance searches as much as possible. But we're going to get into all of that. Evie, you want to get into the next slide, please? Okay, so like I was saying, when it comes to selecting a trademark, my suggestion to you is get ahead of the game. You need to evaluate your trademark availability during the very initial stages of your business development, or the development of your business, the startup of your business, the incorporation side. One of the things that I find clients struggle with sometimes is that they will incorporate a business and they will think that because they were able to incorporate it, then that mark must be available. But that's not true. Another thing that clients sometimes do is they go out and they find a domain name. The domain name might be available, and so they think, all right, well, I've got the domain name, so then that means the trademark must be available. No, that's not true either. You want to actually start with a trademark search and then determine what domain name you want. As far as incorporating the name of your business, I would want to have that information available to me as well, because these are all very separate considerations. A domain name registration is very different from the name that you're going to use to incorporate, which again is very different from the trademark that you're going to select. This is very important to get right early on, because you don't want to go down the road of really developing a brand or developing logos and marks and all of that, only to find that, oh, someone has been out there using something and it's probably not going to be exactly the same, but it might be very, very close. And we'll talk about what being very, very close means a little later on, but I just wanted to make sure that you know that you need to keep all of this in mind before you select that name that you've picked for your business or for your products, and you become really invested in it, and not just invested in it as far as financially, but emotionally we get very invested in what we want to call our product, and we fall in love with it, and that's what it's going to be. You want to pick a strong and protectable trademark, so avoid descriptive brand names and names that are prevalent in the industry. So I think, sometimes people feel like they want to not veer too much from what's already been, what people are familiar with in the marketplace. So, you might be brainstorming, maybe you have a new type of yogurt out there. Maybe you've developed a new type of yogurt that you want to market to grocery stores, and you're thinking, oh, what are consumers familiar with? Well, there's Yoplait, there's Noosa, there's Dannon. And so you're thinking, well, let me just develop something similar to those names so people will kind of be familiar with it and go to my product. You do not want to approach your trademark development that way. You want something as unique as possible and something that doesn't describe your product, because the trademark office will kick it right back. If they even get a whiff of descriptiveness in that trademark that you've applied for, they will push it right back. You want to consider where you want to trademark your product or your business. Most of the time we are applying for federal trademark registrations. We don't really do individual states anymore, even though those are available. If you live in Pennsylvania like I do, you could just register your mark in the state of Pennsylvania. But really, if I was a startup, I'm pretty sure that I'm not going to be restricted to doing business in Pennsylvania. Everyone is doing business all over the world these days, so you want to be sure that that trademark is available everywhere. Once you get your trademark, or even while you're applying for your trademark, you want to police your competitors' use of your marks. You just want to, on a regular basis, check and see, is anybody else, using my mark? You might want to just do that by a simple Google search. Just kind of stay on top of it. This is an asset, just like you wouldn't leave your inventory out in the open without checking to make sure that it's protected. You want to make sure that your trademark that you're investing in is also protected. All right, Evie, let's go to the next slide. All right, here, I thought maybe a good way to discuss this topic is to kind of do a case study. And so I used global entrepreneurship as a sample mark that we're gonna work with. Like I said previously, what you want to do is make sure that the mark is available for you to use. And there are several ways of doing that. You can do a Google search. I always do a Google search. It's easy, it's cheap, it's free. You can do a search of trademark databases, right? So you can do, there are databases in the US that you can go to. There are databases in Europe that you can go to. They are free, and it's really good. It's a really good place for you to start because you can just do a knockout search. If there's a mark that you had been considering and you search for it on the USPTO website and you find something that's almost exactly the same, then you've educated yourself without engaging an attorney, without spending any money, that, yeah, okay, we don't need to do that. But in order to make that determination, you don't need to only look at the mark itself. You also should be looking at the goods and services that it's registered for or that it's been applied for, because a lot of these databases will give you marks that are registered as well as applications that are currently pending. In some cases, it might be possible for you to pursue a mark because it might be that a similar mark has been applied for goods and services that have absolutely nothing to do with what you're doing. You might have a baked good business, whereas whereas a similar mark has been applied for automotive parts. So a consumer in that scenario is not going to be confused as far as the source of that product. A person buying automotive parts is not going to think, oh, that actually came from this business that sells baked goods. So there are these nuanced considerations that you want to be aware of. But I think as a first pass, if you can go on these free databases and do some knockout searches, it's going to be really helpful for you. This screenshot here is from the USPTO Trademark Office website. And this shows you the format in which a lot of the search results are going to show up. Where you see just a serial number, that means that that is a trademark application that's pending. Where you see a serial number and a registration number, that shows you a trademark application that has been registered. The check status is going to show you where you can get additional information about it, and the live dead is going to tell you whether or not that registration or application is alive or dead. One thing I would caution you is where it says dead, don't feel like that you're in the clear, because just because an application has died doesn't mean that there are no rights in that mark, because there's such a thing as common law rights that attach to trademarks, which is a whole other consideration. Like I said, you're just using this search as a knockout search to gather information about marks, logos, images that might be available. Okay, next slide. All right, I think I covered pretty much all of this. So Evie, let's go to the slide after this. All right, so when it comes to filing a trademark application, this is the general process. There are two types of trademark applications. If you are already using a mark, then what you're going to do is you're going to file a use-based mark. If you are in the planning stages and haven't yet launched your mark or your brand, then you can file what's called an intent to use application. Either one is fine. The main difference between the use-based mark application and the intent to use application is that for the intent to use, which we refer to as an ITU, you don't have to provide evidence of use because obviously you don't have evidence of use yet. When you apply for a use-based mark application, you need to have your mark. You need to have a specimen that shows how you're using the mark in commerce. And you need to be able to identify who the owner of the mark is, where your company is incorporated, if that information is available. And you need to be able to list the classes that you want to designate. And by classes, that means where do your goods and services fall? And those classes are determined by the Trademark Manual of Examination Procedure, which you can find on the USPTO website as well. I don't mean to get too granular, but this is I'm just trying to give you a high-level view of the type of information that's going to be required when you file for your application. Same sort of information is required for the intent to use, except of course, you won't be submitting a specimen. Next slide. So if I was filing a trademark application for global entrepreneurship, I would file it in standard character format. And the reason I do that is because if I am successful in securing a registration for global entrepreneurship in standard character format, then I can use global entrepreneurship in any font, any format, any color, anything that I wanted. So if I want it in blue italics or rainbow colored italics or any format that I want to use global entrepreneurship in, I can use it as long as I file for that mark in standard character format. So 99% of the applications that I file are in standard character format. You do not want to file a stylized format if you can avoid it. You file the application, and then the US Patent and Trademark Office will pick it up in about 6 to 8 months and begin the process of examination. Next slide. So when the examiner picks it up, usually there are two types of considerations or two types of review that the examiner is required to undertake. And based on their review of our application, they're going to issue rejections. It's very seldom that no rejections are, made. There's always something that the examiner wants to have you correct. I have a tendency to file broad designations of classes. So if you tell me that you want to protect, that you want to get a registration for cupcakes, I'm going to say, well, let's broaden that to the class of baked goods. So let's have croissants in there, and let's have bread in there. Let's put all of this stuff in there. And then the examiner might come back and say, okay, well, that's too broad. Let's narrow it. But my thinking is I want to try to get you broader protection than narrower protection. So there might be a little bit of back and forth with the examiner with respect to that aspect of the formalities. Another reason that an examiner might reject an application is that they may not like the specimen that was submitted. There's always like, oh, they didn't like the label, or they didn't like the screenshot that we took from the website. It could be any number of things. They may also request a clearer drawing of the mark or their logo. And I'm sorry, I don't think I ever said what a specimen is. A specimen is actually an example of how you're using the mark in interstate commerce. So their favorite type of specimen they like to see is a label on the product itself. When you are advertising goods and when you're advertising services and you're using a brand with services, it can get pretty complicated and nuanced as far as what the trademark office is willing to accept, but we won't go into that too much. So the first type of rejection is a formality rejection. The second type of rejection is more of a substantive rejection. The substantive rejection is going to be any number of things. The one that we get, like I would say 60 to 70% of the time, is the examiner rejects the application saying it is confusingly similar to another mark that's already operating in that same channel of commerce. So, you know, if there's a mark out there, whether it's a pending application or a registration for, say, global business for startups, then we're going to have a really tough time getting a registration for global entrepreneurship because it's just too confusingly similar. And the average consumer is going to be confused. I mean, that's the benchmark. It's going to be confused, not knowing really what's the difference between global business and global entrepreneurship. So you're going to get a rejection there. And that rejection can be based on just one mark, or it could be multiple marks. That's when it starts to get really kind of complicated. Another type of rejection that we are often dealt with from the trademark office is the examiner considers the mark that we've applied for to be merely descriptive. And these are all legal terms with legal implications. So they might say that, you know, your mark just is too close to what it is that you're doing. It describes the services, or it describes the product, and you are not entitled to exclusive protection for that mark or that brand because it's just way too descriptive. And then in these cases, what we do is we prepare a formal response for the examiner. I will typically do a very detailed written response, which I work with my clients. We make legal arguments. We submit them to the trademark office. You can call an examiner and just kind of talk to them and say, yeah, you know, what do you think? What can I do to facilitate this process towards registration? And most of the time, I find that trademark examiners are quite friendly. They will help you, especially if you are an individual that has filed your own trademark application. They'll kind of hold your hand and walk you through it. That's not always the case, but they might be helpful. It's always worth a shot. So from the time that you get the rejection, which we refer to as an office action, you have 6 months within which to respond to that office action. If you do not respond within that 6-month period, your application is going to go abandoned and you're going to have to start the process all over again. There are no extensions of time available. So you better be sure that you get a response filed within that 6-month period. You can always file earlier if you want to. And I would suggest that you do file earlier if you can. Unfortunately, some of us have an issue with waiting to the last possible minute to meet their deadlines, but we won't get into that. Next slide, please. All right, so after you go back and forth with the examiner, and usually that happens at least twice, maybe 3 times sometimes, we're hoping the application is going to be allowed. There are other things that you can do if the examiner is just not budging and you feel like you have a really strong case. Then what you can do is you can file an appeal, but we're not going to talk about the appeal process today. We're just going to kind of walk through the general procedure of what goes on. Once your application is allowed, the patent office, the U.S. Patent and Trademark Office will publish your mark for a 30-day period, which is called the opposition period. So it's published in what's called the Official Gazette, and companies, businesses, branding companies are regularly monitoring the Official Gazette to make sure that if there's a mark that's published that they feel is really something that's going to infringe upon their space, then they can file an opposition. And then that's a whole other process that you will have to get into with some back and forth. If the mark is allowed and the application is an intent to use, it will not be registered until you have provided the trademark office with evidence of use. So typically for intent to use applications, you have 6-month increments within which to provide evidence of use. And the trademark office is very forgiving. They will give you up to 36 months within which you can provide evidence of use. Each time you get a 6-month increment, you have to pay for it. It's not that much money. I think it's $200-300 for getting an extension of time to provide evidence of use. But it does give you some time to work on your branding and make sure that that mark can be supported with use. Sometimes you'll submit evidence of use and the trademark office won't be happy with it and they'll kick it back, and so you'll have to just go through the process a couple of times. Okay, next slide. So costs. I think I mentioned as far as patent applications go, getting a patent application on file can be anywhere from $5,000 to $15,000, maybe more. Copyright registration is going to cost you about $35 in a registration fee. Trade secret is something that you're going to do in-house. With respect to trademarks, the filing fee is $245 per class. So if you are entering into the food space and you want to designate the class of baked goods and you also want to do sodas, those are going to be separate classes. So you're going to be paying $245 twice because that's the filing fee. And you can do this by yourself, or you can engage an attorney to do this for you. And I would suggest that if at all possible, that you engage an attorney to file it for you, because it's a pretty straightforward process. However, there are so many places that you could kind of mess up, and then it would just be such a pain to go back and fix it, that my suggestion to you would be to find a trademark attorney that's going to give you a fixed fee cost estimate that covers filing the application and just getting it to the Patent and Trademark Office. Many times trademark attorneys will also will give you the option of a flat fee for conducting a preliminary search. And I would, if at all possible, I would also try to do that, so that you have a more of a comfort with respect to getting protection for your mark ultimately. So a trademark attorney can give you those fixed fees up front so you can budget for it. Down the road, as the application process, as the application progresses and office actions come up, you can say, all right, well, I see that the examiner issued these rejections. How much are you going to charge me to draft a response to this office action? So that way you can keep costs under control. If you're going to go with an attorney that will not do fixed fee for you, you're kind of subject to billing by the hour, which can get a little out of hand and hard to predict and hard to plan around sometimes, especially for smaller businesses. Another thing that you might want to keep in mind is in the US, if you file a trademark application on January 1, you have a 6-month period within which, actually it doesn't have to be January 1, I'm just saying January 1. From the time that you file your trademark application, you have a 6-month window within which to file in Europe and certain other jurisdictions and go back to your original filing date as a priority date, so that if you have a competitor that launched a product under a similar brand, even if you haven't filed in Europe, you can kind of rely on your US filing date. Again, that's subject to a couple of other details, but I just kind of wanted to let you know that that is something that is available to you. Next slide, Edie. All right, so once all the formalities are satisfied, you've gotten the notice of allowance, you've passed the opposition period, you receive your certificate of registration. The registration remains in effect basically forever. There are maintenance fees that have to be paid anywhere between the 5th and 6th year, and then I think between the 8th and 10th year, and other increments down the road. But basically, you keep it forever, unlike a patent, which is only going to last for 20 years from the date of filing. So you want to make sure that you're keeping yourself abreast of any deadlines that are going to come up for paying maintenance fees. That's another reason to engage an attorney, because attorneys, trademark attorneys, patent attorneys, we have docketing software that keeps track of all of these deadlines. You need to make sure that you take whatever efforts you can to police your mark, prevent other people from using it. Like I mentioned earlier, it is an asset. You need to take care of it and protect it. And an important thing that I think a lot of people don't know is that from the time that you start using a trademark, if you want to protect that mark, you can immediately put TM next to it. Whether or not you've even filed for an application, you can put TM next to it. Again, you're putting the world on notice that this is my mark and I intend to protect it. It's kind of like patent pending, but you don't actually even have to have filed an application in order to use TM next to it. It's possible, that there's the third party out there that already has a mark that's registered and feels like your mark is infringing their mark, and then even putting TM next to it is really not going to get you much protection. However, this really is important in the context of people that are not using your mark and that might be, I don't know, tempted to take your mark from you. I would start using TM immediately, and especially after you file their application, continue using TM. Once the mark is registered, then you can use the R with a circle around it. Okay, I want to keep some time for questions, so I'm going to just quickly go to that. Can you go to the next slide, Evie? All right, these are some really great, useful websites. If you're looking for information about patents, WIPO.org is fantastic. I use these websites. These are up all day long for me. The USPTO.gov is great to get trademark information in the US. And I will leave you with that final website there, DLA Piper Accelerate. That's the resource that I mentioned early on, which is going to provide you with a wealth of information for your startup and for your business, and just anything that you need or questions that you have. I would really just go there and start there and see what you can do as far as educating yourself, and then talk to a lawyer. And I'm going to stop there. I'm sorry, I think I went over the time. If people have questions, I'm happy to take them.
That's okay. Thank you so much, Sima. That was extremely informative and helpful. I definitely am going to use it for my own business ventures in the future, because I definitely think that it's important for all small businesses to at least explore the idea of trademarking their name and their logo. I will be sharing your PowerPoint and this video with everyone afterwards, so you can review it at your leisure. And I do have some questions that are in the chat, and I just want to read them out to you so we can have those answered. So one of them is, which comes first, the chicken or the egg? So this person has already used their logo and name on a website. They've been through the effort of having all the logos rendered and whatnot. But if they want to trademark, they need to be legal first. They already own the domain for their brand, but haven't launched yet. What do I do? So which comes first?
So which comes first? I would, since you've already invested in using this mark, I would engage a trademark attorney as soon as possible to make sure that it's available to you before you actually launch it. I would do that right off the bat, is do a clearance search.
All right, great. And as I mentioned in the chat, Philly VIP does offer pro bono services for trademarks and patents and copyrights for qualifying candidates. So you can email me at icruise@phillyvip.org if you want to find more information, see if you qualify for those pro bono services. You can also check out our website, phillyvip.org, for more information on how to apply. So another question we have is, how do we evaluate a brand? So you mentioned that Coca-Cola's brand was worth 80 billion or $1 million. Not just the company, but the brand itself. So how do you evaluate your own brand?
I mean, that's going to be an assessment that's made, case by case. It's going to be different for big companies. It's going to be, it's just really more of an individualized analysis. It depends on the industry. It depends on, what the consumer field is. I'm afraid there's no formula that can answer that question.
Okay. And another one in the chat here, is it necessary to trademark a childcare brand? Now, I know that you have definitely insisted that we should, but is it necessary?
I mean, it depends. Like, if you are worried that someone is going to steal your brand and that the relevant consumers are going to be confused by a competitor using your mark, then yes. Or if you have a plan to franchise your child care business, and you want your investors to know that this brand is really important, and you're going to expand all over the United States. You're going to have a place in Chestnut Hill, but you're also going to have a place in Stone Mountain, Georgia. So it's really important that you protect that brand. Then yes, absolutely protect that brand. But if your plan as a business is to remain somewhat local, or just be in Pennsylvania, then I think it's not such I can't make a very compelling argument for you to go ahead and really explore federal registration for that mark. But like I said, it's a case by case situation.
That's good to know. Very good to know. Now I have a couple more questions. We have about 6 minutes left. This came from people that had pre-submitted questions when they registered. I'm not sure if they're here today, but I think it's relevant for everybody involved here. Are you able to have one main umbrella trademark and main logo with additional trademarks and logos of subsidiary businesses? Or would I have to secure the trademark and logo fee for all the subsidiary businesses and keep them separate?
So what you can do, if you have a brand and you have several subsidiaries underneath it, what you need to do, this is not really more of a trademark question, this is more of a corporate question. So if you have subsidiaries, what you want to do is you want to license that trademark to the individual subsidiaries. So you don't have to file separate trademark applications for each of the subsidiaries. You can have one trademark registration that is used in a variety, varying capacities by the individual subsidiaries.
Okay, and this is a similar question. So I have a trademark I'd like to use that has interchangeable parts, as in the main part is always the same, but another part of the mark will change depending on the category of the card. So is that possible?
I mean, in that case, I would say protect the core part of your trademark. And if possible, then file separate trademark applications for the interchangeable, for the core plus the various interchangeable parts. I wouldn't, I think that's the safest way to go, but for sure protect the core part of the trademark.
All right. And now what if your business has a partnership? So you say you have two partners that are 50-50 ownership. Who owns the trademark? Do you have to establish that up front? What happens if one partner leaves? How do you handle that?
So again, this is not so much of a trademark question. This is like, how would you share ownership of an asset in a business, right? So you get your trademark registration. It is an asset. It belongs to the company. And then however the company ownership is determined, that can be how ownership of that trademark is determined. There are a million different ways to do this. Or, if you are the individual that got the trademark and you want to license it to the company and perhaps give your partner X percentage of rights in the trademark, you can do that. There are lots of different ways of setting this up. You just need to think about what's going to make sense for your business. The considerations for trademarks with respect to co-ownership of that asset are very different and a lot more amenable to individualized, customized situations as compared to patents.
All right, and I do see in the chat that we have a follow-up to that other question of whether you need to trademark the subsidiaries under an umbrella brand. They're still confused. So do you need to trademark the brand and all of the subsidiaries underneath it?
Well, I mean, if the subsidiaries are names and it's those names.
I think your sound is cutting out a little bit there. I'm sorry.
Oh, can you hear me now?
Yes, that's great.
Okay. So if the subsidiaries have different names that you want to protect, then in a perfect world, I would say yes. File trademark applications for each of the separate subsidiaries. Okay,
great. Hopefully that cleared it up for that person. So we have a couple minutes left. So what if you trademarked your logo, you got it all registered, but a little portion of it changed, you want to update the graphic or the name. So do you have to start from scratch, or is there kind of a shorter process by which you can amend your existing trademark?
You basically have to start from scratch. Yeah, and again, it depends. Like, it depends. If you file your logo in black and white, then you're not restricted to black and white. You can put it in any color or any shading that you want to use. Then you have a little bit more available to you as far as the type of modifications that you can make to your registration. So it really depends on how much you're modifying the mark and what you originally filed for.
Well, that's a great tip that I didn't realize. So if you file the logo in black and white, you have a little bit more wiggle room to change things as time goes on. That's interesting.
Yes. Yeah,
okay.
The color anyway. Yes, you have wiggle room with respect to color. For logos, filing in black and white is the same as filing a word mark in standard character format.
Okay. And we have one last question because we're coming up on time. Do we have to be a legally established corporation or LLC to file for the trademark?
No, you do not. No, you can file as an individual.
Okay, great. And one last question from the same person. Can we use our trademark in one area, like as in a consulting use, and also use it for clothes and pencils? So if this trademark is being used for one type of service or business, can you reuse it for a different type of business, such as retail versus service?
Yeah, no, absolutely. Like if I get a registration for, say, clothing, and then I want to use it for consulting services, that's fine. But my application that I submitted for that mark may have only been for clothing, right? Mm-hmm. And so I might need to file a separate application to protect it for consulting services. But just because you have it for one category of goods and services doesn't mean that you cannot use it for something else. As long as there's no conflicting mark out there, you should be fine. Again, all of these things are so nuanced and like a case-by-case determination that it's hard to give a blanket answer as far as what you can do and can't do.
All right. Well, so that's all good to know. So I will be sending out the PowerPoint, and it's going to have the website with all of the resources that you shared, including DLA Piper's own resource hub for trademarks and other legal services that you might need to start up your business. Again, you can contact me. I'll be when I send out that follow-up email, you can always respond to me if you need additional services after this presentation, or if you want to take a stab at it on your own, you can use that PowerPoint as a resource. So thank you all for sharing your lunch hour with us. Sorry for the technical difficulties at the top of the hour. And thank you, Sima, for sharing your wealth of knowledge with us in how to trademark our business. And I hope you all have a great rest of your afternoon. Thank you so much.
Evie. Thanks, everybody. Bye-bye.
Take care.